Ready? 3, 2, 1, start. This view has been reiterated, approved, and followed by this court in S.S. Rathi. The reliance on affidavit by the High Court would be a weak and unreliable source for adjudication on the fate of a trial. Having regard to the aforesaid position, the authority concerned has the discretion of choosing the appropriate forum who is empowered to decide before which court the proceedings shall be instituted, and in this regard the decision can only be made when there is material before him in the form of charge sheet filed or presented by the police before a magistrate after conducting investigation, and in fact this decision cannot be taken merely on the basis of a report or complaint. It is profitable to mention here that a situation may arise where the concerned officer fails to take the decision as per the power vested in him by the relevant provisions. However, such a scenario is contemplated under Section 521 of BNSS, which is an enabling provision and empowers the central government to frame rules regarding the cases. When any person is brought before a magistrate and charged with an offence for which he is liable to be tried either by a court to which this code applies or by any other court, then such magistrate shall have regard to such rules, and in proper cases he shall deliver him together with a statement of the offence of which he is accused. What emerges from above is that when a person subject to such law is brought before a magistrate and charged with an offence triable either by a court governed by the CRPC or any other law, then the magistrate is mandated to act in accordance with the relevant rules. However, the magistrate can forward the statement of offence only when such a statement is filed or presented before the magistrate by the police. The application was rejected by the magistrate on the ground that the stage for consideration would only be on the completion of the police investigation. The order of the magistrate was challenged before the High Court in revision, and the challenge was rejected. The two-judge bench held that the decision regarding the trial of the accused could be exercised only after the police had completed the investigation and submitted the charge sheet. In that case, the police had merely commenced the investigation, and hence the rejection of the request by the magistrate was upheld. Pursuant to the filing of the appeal, notice was issued to the respondent state. It is argued that the main ground of the revisionist is that in the complaint justice is missing. It is further argued that the procedure under Section 340 CRPC is invoked when any offence is affecting the administration of justice, that is, when there is any interference in justice or false claim or statements are made before any court, and it is not essential to mention the particular words in the complaint made under Section 340 CRPC. Ashok Malhotra versus State has clarified the position in this regard. It is argued that in the present case, civil judge had considered the material on record and conduct of the accused is reflected from the detailed order passed by the civil judge. It is also argued that the conduct of the accused also finds a mention in the order passed by the Chief Metropolitan Magistrate, that is, how accused made a false claim before the court of civil judge and also did not appear before the court when he was asked to produce the attorney, and hence the procedure under Section 340 CRPC has rightly been followed by the courts. It is further argued that the court has rightly held that case is to be seen from the prima facie view, and there is no requirement of passing a speaking order because under section 343 CRPC, the magistrate has to deal with the complaint referred in section 340 CRPC as if it was instituted on the report received from police. Therefore, all the offences referred above fall within the purview of warrant cases. The issue before the apex court was whether any documents which the accused may rely in support of his defense could be looked into at the stage of framing of charge or not. It was held that at the stage of framing of charge, the court will not weigh the evidence as the stage for appreciating the evidence for the purpose of arriving at a conclusion is where the prosecution was able to bring home the charge against the accused, and it would arise only if the evidence is brought on record at the trial. Stop. ये 130 words per minute.